And once again, I would like to introduce Leah Wiener, PhD candidate in the Department of History at Simon Fraser University, with her lecture on Jordan's Principle, Past and Present. Leah.
Okay, good morning, folks. So moving forward just to our next slide here. Bettina has kindly introduced me. So I'm a PhD candidate at SFU. And for those who are maybe newer to post-secondary studies, a PhD would be the third degree that someone might do in university if they're looking to specialize in their field. And in addition to being a student here, I also am teaching a couple of classes in the history department at SFU. So this semester teaching disability history, and next semester teaching a course on the history of epidemics in Canada. What is Jordan's Principle? It's named for a boy named Jordan Anderson, and Jordan Anderson never got to see his home. He died in 2004 at the age of 5, and he was living at that point in a Winnipeg hospital. He came from Norway House First Nation, but because he had a rare neuromuscular disorder, so a pretty significant disability, he needed a lot of medical care and equipment to help meet his health needs. So the Manitoba government and the federal government argued for his whole life about who would pay for home care on Jordan's Indigenous reserve. And Jordan remained in the hospital waiting to go home and back to his community. And unfortunately, he died before these jurisdictions came to an agreement. Jordan's Principle is named after him. So there's some words that you'll need to know to really understand this best. So the first one is jurisdiction. Jurisdiction, we could say, is the power to make laws, with juris meaning law and diction meaning speak. In Canada, this power is divided between provinces and the federal government. And then there's also some powers for cities and for Indigenous communities. The British North America Act, which was enacted in 1867 as part of Confederation, laid out these powers. Today, the important thing to know about jurisdiction is that jurisdiction over Indigenous people was given to the federal government, but jurisdiction over healthcare was given to the provincial governments. So decisions made more than 150 years ago about who gets power over what, to some people sound a bit old, a bit boring. I hear that sometimes from first-year history students that, they found history not to be as exciting. But actually, this is really important because it's what meant that this little boy, Jordan Anderson, never got to go home to the place where his family loved. And he spent his whole life living in a hospital. And anyone here who's ever spent time in a hospital would know that it's not really where you want to spend 5 years. So something, like the British North America Act is not just an old document from, the 1800s. It's actually something that really profoundly affects our lives. In 2007, a member of parliament named June Crowder introduced a plan called Jordan's Principle. And this principle said that if a child needed services, such as home care, for example, or medical equipment, a province or the federal government, whichever one met the child first, would pay for it. And then those levels of government could sort out who paid later on. One important thing to know about Jordan's Principle is that it wasn't a law, it was just a vision. So it's been hard to enforce. The MPs voted to pass this, but it didn't really mean anything about how children would actually get services. The other important thing to know in terms of a term that I might talk about is confederation, which is the 1867 political decision to bring together provinces and into Canada. And that was done through the, through the British North America Act. So why is Jordan's Principle important? Take a moment to write down some of your thoughts in the chat window, but don't hit return just yet. Okay, so we have someone who says on the slide that This is sadness for them that a child died while adults argued about who pays. And we have here the definition of an adult is someone who is or can be responsible for children. And this is enshrining the idea that the country is run by adults. So we sort of have this split between childhood and adulthood and what that means. This is actually a really big question that we talk about when I teach history of childhood courses. Yeah, and then someone else is bringing the question of Indigenous and settler relations into this. So it's important to give Indigenous peoples access to healthcare while they've already been marginalized throughout our history. So it seems like you're thinking, you're already thinking about some of these big issues. We have questions about adulthood and childhood, questions of what it means to be Indigenous. And often when I give this presentation, people talk a lot about truth and reconciliation as well, and this ongoing question of settler colonialism. So one thing that historians do is figure out how and why things happened in the past. So, but in the past, we talk here both about 2007, when Jordan's principle was brought in, as well as 2004 when Jordan died, 1999 when he was born. But we can go further back. It's easy to think about Jordan's principle as something a bit more recent, responding to this one little boy's death. But I was pretty sure when I first heard about this that Jordan wasn't the first child who fell in the middle of this sort of dispute. So I went to the archives. Some of you might have been to an archive of some sort before, but probably most of you wouldn't have unless you've been studying history for a bit. And archives are a little bit like a time machine. So you can find photos, files, videos, all sorts of things about the past. In a sense, they're a bit like a library, a bit like a museum, a bit like a bank vault. And there's all sorts of things in there. So when I went to visit the archives in Ottawa, I found files about lots of other children dating back about 100 years. Until the 1960s, it was harder for children to get care in a hospital because up to that point, the provincial governments didn't pay for healthcare for everybody. There wasn't MSP in those days like we have in BC now. If someone was very poor, sometimes they could get medical care without paying, but they had to prove that they really had truly no money. And sometimes the hospitals just wouldn't believe them. So a lot of the time people would try to pay medical bills and then have no money left for food, for rent, or for clothing, or sometimes they had to choose not to go to the doctor at all, and then they would get very sick. And that got very complicated for kids who had serious illnesses or disabilities like Jordan did. So I'll give you an example here. In 1942, a 10-year-old boy who lived at a residential school in Northern Ontario was diagnosed with tuberculosis. These days, tuberculosis can be treated with antibiotics, but in the 1940s, it was fatal for a lot of people. Some people could get treatment at a specialized hospital called a sanatorium, but that could be really expensive. In the case of this child, the school did decide to send him to a sanatorium. For the sake of this presentation, I'm going to call this child James, but that's not actually his real name. So to get access to private records in the archives, I had to write some letters and fill out waiver forms that I sent to the privacy commissioner. And part of my agreement with the archives was that I wouldn't share people's real names. I can share some of the letters that were written about him as long as I black out that sort of identifying detail. So I'll pull up this letter now so we can take a look. So this sort of primary source is a fairly common thing that historians would use, an old letter from the past. And I'm interested to know what kinds of things you see in this letter. So feel free to underline or circle anything that you feel is interesting, or to write stuff down in the margins. I'll give you a minute to read along. And for those who maybe don't have as good, screen sort of access, I'll read aloud with you. So this boy was admitted to the school by authority of letter 65-110 of September 9th, 1941. Shortly afterward, it was discovered that the father of the boy was reputed to be a white man, and a letter under the same file number of September 26th advised that he should be returned home as soon as possible. Traveling conditions and the fact that his parents would by then be out of touch with civilization prevented his being sent home, and a further letter of October 17th, 1941, left it up to myself and the school principal to have him returned at the earliest opportunity. Being examined along with the rest of the children, he was found to be suffering from tuberculosis, and your letter advised me to have him put in a sanatorium. I am told that Archbishop Anderson of Cochrane, for those who don't know, Cochrane is a small town in Northern Ontario, who was mainly responsible for the boy being sent here, would be in Chapleau this weekend, leaving on Monday, and thought that he might be able to take him back part of the way and see that he was either sent to an institution under the province of Quebec, in which province he resides, or returned to his parents. And I see here someone has highlighted this sort of concept of out of touch with civilization, and then this question of his father being a white man. And those are both sort of very important things to bring up here, is that there was this notion under settler colonialism that Indigenous people were not civilized, and that was one of the main reasons for residential schooling, was to change them in that way. The question of his father being a white man was also really relevant, because one of the questions in the Indian Act, which is a piece of legislation that regulated Indigenous people, was that they determined who was Indigenous based on the race of their father. So who your mother was wouldn't matter as much as who your father was in determining what services you got. And this could also cause a lot of problems, firstly, if you didn't know who your father was. But it also still causes problems for Indigenous people who have Indian status, which is a legal status that you would get through their mother's line, often don't have the same rights as people whose father or grandfather might be Indigenous. And then someone else here has highlighted sort of the role that the school principal and the person who wrote the letter, who's the Indian agent, took as sort of the people who had authority over managing this child. Just going to save these and then clear to move to the next slide here. So our next page then says, he not being a treaty Indian, the department are not responsible for his care. And I hardly think the fact that he has spent some time in one of our schools would leave that responsibility with us. Of course, it may not be possible to have the Archbishop take him back, but I thought it was worthwhile trying to get him away. And unless I receive instructions to the contrary, I will endeavor to have this done, and will give him the clinical report on the boy's condition, so that if possible, he will be looked after by the proper authorities. So an Indian agent was someone who basically was in charge of an Indigenous community. And this person, the only real qualifications for this job was that you had to be a man, you had to be white, and ideally you had to be able to read and write, although there are some cases where people couldn't. And they had all sorts of power over Indigenous people. So they could decide whether or not you were allowed to see a doctor. They could put a child into a residential school. And in some areas, they even had power to tell people that they had to stay on their reserve and that they couldn't go, for instance, into the city to get food, further out into a forest to hunt, for example, or even to a neighboring town to visit their own relatives. So here we can see another follow-up to this letter, talking about how the child was ultimately found to have minimal tuberculosis, and that one of the challenges that they ran into is that only his father was Indigenous and not his mother. And based on that, they decided that he was not the responsibility of the federal government. This meant that they refused to accept any charges for his treatment. So some of the things that I found really interesting about this source is that this boy was eligible to be confined in a residential school and removed from his family. But then when they found out that he was sick, that they were not willing to pay for the expenses of his medical care. Another really important thing here is this debate over his status as an Indigenous person was really important for who paid for his care. So James was pretty different from Jordan in this way, because Jordan, there was no debate over whether or not he was Indigenous. The question in Jordan's case was just who was responsible for paying for his care. And there are a few cases like that in the archives as well, and I'll show you one of them. And I'm calling this girl Ruth, which again isn't her real name. It's unclear how old she is, but we do know that she also had tuberculosis because the hospital that she was placed in was dedicated to tuberculosis. So let's see what we can find in this letter. I'll read it along with you, and feel free to highlight anything that you find interesting here. So they acknowledge that they've received the letter and then say, this girl has not resided on a reserve for several years, although she has been on Sucker Creek Reserve for short periods as a visitor at her grandparents'. Her parents are separated at the present time. The father is sickly and staying with his mother-in-law at Sucker Creek Reserve. The mother, who is of disreputable character, is living with, and then I've had to black out the full name of the parents, who comes from Chagwianda Band, which is another neighboring reserve, in a white settlement. I would hesitate to say that Ruth had lived steadily in town of Little Current since 1941, although the parents have been around that area for most of the time. The family are so shiftless, it is difficult to account for their continued residence, but I know that they have had no permanent residence on a reserve for several years, and I would consider Ruth is not a responsibility of this department. So I can see here, Sarah, you're commenting that the family here is of disreputable character, and the family are really shiftless as sort of things to pull out. So we can see here a lot of these attitudes that federal officials would have had towards Indigenous people. Yeah, and you're saying it's a breathtaking lack of respect and empathy. And I find it really striking here that what we're talking about in these letters is a child, in some cases, like a fairly young child, being taken and removed from their parents to be placed in a hospital and quite possibly never seeing their family again. And the letters inevitably just talk about the bureaucracy and the payment and never about the impact on this young person who is being sent away. Another thing, sort of when you read between the lines in this letter, that's interesting is this notion of the reputation of the mother. Usually in the 1940s, when they used that kind of phrasing, that, you know, she has a poor reputation, what they're talking about most likely is that she is having sex outside of marriage. And that was a really important way that they regulated women at the time, and to some degree still do today, is condemning women who are having sexual relations not with their husband. And this was in particular a way that they regulated Indigenous people by forcing them to, for instance, get married, attend churches, and behave in very specific ways. This notion of the family being shiftless is also really interesting. Because when we think about who is shiftless, that meaning moves around a lot, what the causes might be for this moving around often is poverty. So when we think about people, even now, who live in the same place for 20 years, that most likely means that you owned your home for that length of time and that you had the ability to stay there. Whereas in contrast, someone who moves every several months, it might be because they keep getting evicted for not paying their rent. And that would have been a similar question back in the 1940s, someone who's forced to move around. It also relates to how Indigenous people lived for a long time, hunting mostly off the land. So it would be fairly common in this part of Northern Ontario for Indigenous people to live for part of the year in a reserve, in a sort of small village, and then to move into the bush and go hunting for another part of the year, and to move following animal migration patterns or follow what animal was most suitable to hunt at a particular time of year, and to move to fishing spots and so forth. So this idea of being shiftless is tied both to questions of poverty and to what it means for people to be white or to be Indigenous at that time. So just by looking at a couple of letters, we can see a lot of different themes in the history of Indigenous settler relations. So why do we have Jordan's principle and not, for instance, James's principle or Ruth's principle? That would be because of the historical context of the early 21st century being really different from the middle of the 20th century. And historical context is something that historians will discuss a lot here. So in the 1950s and the 1960s, Canadian doctors and politicians debated pretty extensively whether and how various types of medical and institutional services should be covered. Arguments like for James's or Ruth's care would have been pretty common up until the 50s and 60s for both Indigenous and non-Indigenous kids. And the difference here is that we can see really blatant racism in the treatment of Indigenous kids when they're discussing whether or not health would be covered. By 2007, there would have been a much bigger gap in the funding for Indigenous and settler communities in Canada, because we have things like MSP in BC, and the sources I'm talking about here are from Ontario, where they have OHIP, Ontario Health Insurance Plan. Another important change that we see by the early 21st century was that the Canadian government, the media, and the general public think very differently about Indigenous issues. So at the time that these letters were originally written, Indigenous people objected pretty extensively to the residential school system because they recognized that their children were being quite terribly abused there. But the government continued to think of it as an important tool for child welfare. 2007, in contrast, was right before the Truth and Reconciliation began. It was 1 year before Stephen Harper's apology about residential schools, which I still think was mostly a media stunt, but nonetheless, it's a media stunt that would have been very unlikely to have happened half a century previously. 2007 was also 11 years after the schools closed down. And so there was a more widespread understanding in Canada at that point that Indigenous people have faced significant injustices at the hands of the government. We also talk now a lot more about Jordan's principle because of the Truth and Reconciliation Commission. And that's really brought a lot more awareness to the impact of settler colonialism. I've been teaching history at SFU since 2012, and I've noticed that even over these past few years, that there's been a huge change in awareness that students have about residential schooling in Canada, because we've really had this cultural shift in how we respond to Indigenous people and Indigenous history. It's still not quite enough. We still have a lot of learning to do and a lot of really practical changes to make, but it is great to see that incoming students are far more likely to have heard about residential schools. That being said, often when I teach Canadian history, students who know a bit about Indigenous history think immediately of residential schools. But it's important to know that Indigenous history is a lot bigger than that. So we need to talk about residential schools, but we need to talk not only about residential schools. So not all children went to residential schools. Some of them, for example, were institutionalized in other places, like tuberculosis hospitals, or other institutions. So I have some sources which I unfortunately can't show you today, that were treatment centers for children who had emotional or mental health challenges. And some of these children were confined in these hospitals for many years, often without the consent of their parents, and very seldom with the consent of the child. Some kids did get necessary medical treatment in hospitals. So I'm not saying that hospitals are a bad thing. Of course, they're really important. But often children were sent to hospitals where they died without receiving necessary care. We also need to think about Indigenous history in terms of the injustices that happened in Indigenous communities at the hands of the federal government and also the provincial government. So day schools in Indigenous communities receiving insufficient funding, and many communities that didn't have clean water, and in many cases still don't. And these are things that a lot of Indigenous communities continue to fight for. So one of the roles of historians is to understand that a lot of these current issues didn't sort of appear out of nowhere. We can trace them back to legal decisions. So for example, connecting the dots between the British North America Act in 1867, the Indian Act, which was 1876 and is still in force, and it regulated Indigenous people, and then all of the different provincial and municipal health and welfare legislation. So connecting all of these dots is one of the things that historians do. So that is my analysis here of Jordan's principle, but I'm sure that some of you have questions, comments, and other thoughts, and you can feel free to ask me about Jordan's principle specifically, or also about Indigenous or Canadian history more broadly, or just about studying history at SFU.